2 minutes. 1 minute. Okay. This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in a public forum is forbidden and shall be addressed in appropriate manner to eliminate all conflict and false allegations. Is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, county, city, or township agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in appropriate manner to eliminate all conflict and false allegations. Is there anyone in attendance at tonight's meeting that is an agent of any law enforcement agency of a federal, state, county, city, or township agency present? This is also for notaries, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. One last time. This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in a public forum is forbidden and shall be addressed in the appropriate manner to eliminate all conflict and false allegations. Is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, county, city, or township agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. Awesome, we're not. Neither of us are working for the de facto government. Let's close in a prayer, open with a prayer. Holy Father, bless our meeting with eyes to see and ears to hear, that the messages and information being presented with an open and caring and compassionate heart for our fellow brothers and sisters, as it shall be done. Take it away.
Let it be done.
Glenn?
Thank you very much, Lori.
Let
That
it
was
be done.
great.
You're welcome.
We need to get in the habit of doing that more, I think.
Absolutely. I agree.
So we're doing this mandatory judicial notice of 12 presumptions. This is something that I got a hold of, and I've made a few changes to it, and there'll probably more, but this will give you the idea. Actually, I was thinking about recording this in the county in Arizona. So anyway, this is a bit of a work in progress right now, but this will give you the idea. The presumptions are valid. It's just how to get it into the public. Um, it needs to be filed into a court case. This is actually done as an exhibit to something else, and I'm not even sure what it was an exhibit to. But there's a lady that is brilliant, and she has been coming to our meetings lately here in Texas, and this is one of the things that she brought in, and I really like it. That's the reason I'm bringing it up. But anyways, so you know that the bar is a private guild. Okay, so the presumption of public record is that any matter before a court is a matter of for the public record, when in fact it's presumed by the members of the private bar guild is a private bar guild business matter. This presumption is rebuked and rejected, and hereby demanded this matter to be on the public record. You know, this is brilliant because it is a private bar guild. They're a bunch of thieves and pirates, and this just exposes the whole thing, eh? Anyways, the presumption of public service is that all members of the private bar guild who have sworn a solemn absolute oath to their guild and then act as public agents of the government or public officials by making additional oaths of public office that openly and deliberately contradict their private superior oaths to their own guild. This presumption is rebuked and rejected. The claim stands that these private bar guild members are legitimate public servants and therefore trustees under public oath. The possibility of this matter being a private matter is rebutted. All persons engaged in the matter at hand are deemed to be in the public service as public servants. So you defeat their presumptions, and it makes it very difficult for them to proceed. Okay, the presumption of public oath is that all members of the private bar guild acting in their capacity as public officials who have sworn a solemn public oath remain bound by that oath and therefore bound to serve honestly, impartially, and fairly as dictated by their oath. It is openly challenged and demanded that the presumption stands that the private bar guild members have functioned under their public oath in contradiction to their guild oath. It is openly challenged, and such individuals must recuse themselves of having a conflict of interest and cannot stand under a public oath. The possibility of this is rebutted, and all public servants acting on behalf of this matter are required to state all sworn oaths, both public and private. I'm telling you, this is actually pretty brilliant. The presumption of immunity is that key members of the private bar guild in the capacity of public officials acting as judges, prosecutors, and magistrates who have sworn the public oath in good faith are immune from personal claims of injury and liability. It is openly challenged and their oath demanded. The presumption stands that the members of the private bar guild as public trustees acting as judges, prosecutors, and magistrates are immune from personal accountability for their actions. This is absolutely rebutted. Any person acting as an agent for a nameless, faceless corporation is wholly personally responsible for their actions on behalf of the corporations. All actions incurring any degree of injury will incur notice of injury, including severe financial penalty. The presumption of summons is that by custom, a summons unrebutted stands, and therefore one who attends court is presumed, I gotta fix this, presumed to accept the position, defendant, juror, witness, and jurisdiction of the court. Attendance to court is usually invitation by summons, unless the summons is rejected and returned with a copy of rejection filed prior to choosing to visit or attend. Jurisdiction and position as the accused and the existence of guilt stands. The presumption is absolutely rebutted on this occasion, on past occasions, and on all future occasions. However, at no time as I am absent nor silent with regard to the matters at hand. I think that's supposed to be was I.
I like that.
Yeah, there's a friend of mine actually that rejected a summons, and the case went away. The presumption of custody is that by custom, if a summons is not rebutted, it stands, and therefore one who attends court is presumed to be a thing, and therefore liable to be detained in custody by custodians. Custodians may only lawfully hold custody of property and things, not flesh and blood, soul possessing beings, unless this presumption is openly challenged by rejection of summons and or at court. The presumption stands you are a thing and property, and therefore lawfully able to be kept in custody by custodians. This presumption is absolutely rebutted. I am alive and well and a man. I'm not in custody by custodians or guardians. I am not a thing. I'm not a property of the court. Under no circumstances may I be detained in any way whatsoever, not at any time, past, present, or future. The presumption of the court of guardians is the presumption that you may be listed as a resident of a ward of the local government area. You are a pauper, therefore are under guardian powers of the local government and its agents as a court of guardians. Unless this presumption is openly challenged to demonstrate you are both a general guardian and general executor of the matter before the court, the presumption is rebutted, and I am by default a pauper, a lunatic, and therefore must obey the rules of the clerk of guardians, the clerk of the magistrate court. This presumption is absolute, rebutted. I am at all times a man sui juris and have possession of much more than 21 silver eagle coins with a face value of $1 and therefore fail to be a pauper. That's something I added in, actually, about the $21. The presumption of the Court of Trustees is that members of the private bar guild presume you accept the office of trustee as a public servant and government employee just by attending the court, as such courts are always for public trustees by the rules of the guild and the court. Unless this presumption is openly challenged to state you are merely visiting by special attendance to clear up the matter, and you are not a government employee or a public trustee in this instance, the presumption stands and is assumed as one of the most significant reasons to claim jurisdiction simply because you appeared. This presumption is absolutely rebutted. Absolutely no jurisdiction at any time may be claimed by the private bar guild and the court over me. The office of trustee is rejected. The role of public servant and government employee is rejected. I'm entitled to common law, not Roman law, as described in Article 6, Clause 2 of this Constitution for the United States of America. And that's Article 6, Clause 2. This Constitution shall be the law, and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. Because law of the land phrase is a convertible phrase with common law, the principle that no person shall be deprived of life, liberty, or property except by due process of law did not originate in the American system of constitutional law, but was contained in the Magna Carta, sometimes referred to as Chapter 29, confirmed on the 19th day of June 1215, declared that no freeman shall be taken, imprisoned, or diseased, or outlawed, or exiled, or in any way destroyed, nor shall we go upon him, nor send upon him, but by the lawful judgment of his peers, or by the law of the land. It has even been said that the principle was known before the Magna Carta, and that it was originally designed to secure the subject against the arbitrary action of the crown and to place him under the protection of the law. It is settled beyond question that this principle came from England to America as part of the common law and has been a fundamental rule in common law. When first adopted, the Magna Carta, the phrase law of the land had reference to the common law and has been a fundamental rule in common law. And that's Book 16, American Jurisprudence, Constitutional Law, Section 543. The presumption of government acting as two roles, as executor and beneficiary, is that for the matter at hand, the private bar guild appoint the judge, magistrate in the capacity of executor, while the prosecutor acts in the capacity of beneficiary, the trust for the current matter. Unless this presumption is openly challenged to demonstrate you're both a general guardian and general executor of the matter before the court, the presumption stands you are by default the trustee. Therefore, must obey the rules of the executor, judge, magistrate. See, this is one of the things that I need to demonstrate you're both the executor, general guardian, and general executor. I don't like that. And so this is going to be tweaked. I just got to figure out how I'm going to do it. Therefore, must obey the rules of the executor, judge, magistrate. This presumption is rebutted. I'm a man and you're a minor estate. 31 CFR 363.6 was created by fraud and deception by the Pope, because the Pope owns and operates the Crown of England and the Kingdom of England and Ireland, the City of London, and now the United Kingdom since the concessions to the Pope. And this is concessions to the Pope, 1213. We will establish a perpetual obligation and concession that from and after the special revenues of our aforesaid kingdoms for all the service and customs which we ought to render for him, saving in all things the penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling. Because King John gave them to the Pope and agreed to rent them back for 1,000 marks a year with the concessions to the Pope, 1213, and the Pope's owned and operated Crown of England created the Sesticay V Act of 1666. Yet still it was found difficult to set bounds to ecclesiastical ingenuity, for when they were driven out of all their former holds, they devised a new method of conveyance by which the lands were granted not to themselves directly, but to nominal fiefs to the use of the religious houses, thus distinguishing between the possession and the use, and receiving the actual profits, while the season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the clergy. That's the Roman cult, folks. Ecclesiastical ingenuity is the Roman cult, folks. To be bound in conscience to account to a sesticay use for the rents and emoluments of the estate. That's taxes, folks. And it is to these inventions our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And that's Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of Morton, Maine, which was brought into America with the Code of Law for the District of Columbia in 1901. An act to establish a code of law for the District of Columbia, the legal estate to be the sesticay use. That's at 31 Stat 1432, which is now codified at 31 CFR 363.6 and unconstitutional because this is what precipitated the War of Independence. And this is the cause of necessities for taking up arms. Statutes have been passed extending the courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, instead thereof to publish and order the use and exercise of the law martial, and for altering fundamentally the form of government established by charter. We saw the misery to which such despotism would reduce us. That's dictatorship, folks. And I got to step aside. I'll be right back. Give me about 2 minutes.
Hi, Mary. Nice to see you. Nice to see you too, Lee.
I thought I heard my name. This is getting good.
Yeah, he's always recreating the wheel, you know. That's an engineer for you.
Yeah. I got to start working on my own case since I know all the bad things they did.
Yeah, I was just thinking that myself because this would be a good opener of beating every assumption up right off the bat. And he said that he's made this into, it's an exhibit.
Uh-huh. And he wanted it to become a public record or something like that.
Yeah, he wants to file it into a specific case. I'll ask him which one. But yeah, it's a very good idea because it rebuts everything immediately.
He just described my whole case to me right there. He described it right in there. Everything that happened to
Mine
me.
too.
No matter how white you are, they're not listening to you because they're bar members and they want to take it. You know. So.
Okay, I'm back. I was just thinking that I want to add something into that. So,
we're saying that you're an engineer, so you're always wanting to reinvent the wheel.
I'm an engineer, so what?
You always want to reinvent the wheel, like you're rewriting this, so.
Yeah, I like to tweak it. Yeah, for sure. Yeah, there's something I want to add in.
There was something I wanted to bring up just as an add-on to once you finish that.
Here we go.
I have a question.
Okay.
I had someone, he was an attorney who's no longer living, but he said he would weave things into the case and the judge would recognize these things, words, and he would repeat them at least 3 times in the case. And I was wondering, should we kind of weave this in and repeat it work it into the case?
You know, if you want to object 3 times, I've heard of that.
Uh-huh.
It's up to you. I would definitely
Yeah.
file it, and I would definitely confront them with it,
Yeah.
and um, see if they'll give you a ruling. That's even better. But
Yeah.
you know, you have to be careful about confronting the judge because there is a thing called contempt of court. Of course, you
Yeah.
know, I found that the one time the judges were real nice to me is when I told them I have nothing but contempt for you and your so-called court. But I did it by mail. I didn't go in there and actually say that kind of stuff. So, you know, you have to. I don't know. It's a judgment call. Anyway, so
Well,
this is, and not long after this, by general excommunication of the king and people for several years, because they would not suffer an archbishop to be imposed upon them, King John was reduced to such straits that he surrendered his kingdoms to Pope Innocent III to receive them again and hold them of him under the rent of 1,000 marks. So there's what happened. Anyways, um, so we're back to here. And the organic law of the Declaration of Independence shows it was listed as reasons for Declaration of Independence from the Vatican's tyrant. He's combined with others. Matter of fact, I think I'll change that to the Pope's tyrant. He's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation. That's talking about, yeah, I'm going to talk about that in a second. Transporting us beyond seas to be tried for pretended offenses. That's the Sesta KV Act. Imposing taxes on us without our consent. That's the Sesta KV Act. Depriving us in many cases of benefits trial by jury, taking away our charters, abolishing our most valuable laws, altering fundamentally the forms of our government. Abdicated government here by declaring us out of his protection and waging war against us. And he has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws. Can only be talking about the Pope's Roman law and the minor estate. And his Sesta KV Act of 1666. And the minor estate, 31 CFR 363.6, is a fiction of law which was invented by the Roman praetors under the pretense of doing equity. And this is a Bouvier's Law Dictionary, 1856 edition. Fictions were invented by the Roman praetors were nevertheless willing to derogate from it under the pretense of doing equity, and fictions of law owe their origin to the legislative usurpations of the bench. And this is important right here. Fictions of law owe their origin to the legislative usurpations of the bench. And why that's important is because it's a bill of attainder. Because a bill of attainder is a legislative act that applies to named individuals to inflict punishment on them without a judicial trial. And that's taken from U.S. versus Brown, U.S. Supreme Court. A bill of attainder is a special legislative act prescribing punishment without a trial for a specific person or group. So when they issue an order of commitment, okay, that's a bill of attainder because it's a legislative act. It's not a judicial act. Bill of pains and penalties, a legislative act, though similar to a bill of attainder, prescribes punishment less severe than capital punishment. So a bill of attainder is actually capital punishment, death penalty. A bill of pains and penalties is less than capital punishment. Both of them are prohibited by the U.S. Constitution, Article 1, Section 9. Actually, under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. And Article 1, an amendment, which says Congress shall make no law respecting an establishment or religion, because it's from the Pope's Roman law, also known as canon law. And I require the minor estate to be dissolved and liquidated immediately. I don't care what you do with the fake money in the Treasury Direct account, because you can put it up your rectal orifice for all I care. I demand that it be dissolved and liquidated immediately. So, the only thing is I still have to deal with this. Let me just... I just want to highlight that because I want to come back to it. Right. Okay, so I just got to come back to that and figure out how I'm going to deal with that. So the presumption of executor de sans tort is the presumption that the accused does not seek to assert their right as executor and beneficiary over their... Right. So this is stuff that needs to be dealt with too. Therefore, the judge assumes the role of the true executor and has the right to have you arrested, detained, fined, forced into psychiatric evaluation, unless this presumption is openly challenged by not only by asserting one's position as executor, as well as questioning if the judge or magistrate is seeking to act as executor de sans tort. The presumption stands, and a judge or magistrate of a private bar guild may seek the assistance of bailiffs or sheriffs to assert their false claim. This is rebutted. Under no circumstances may the judge attempt to assume the role of executor before any personal attendance. Before a court is undertaken to discuss the matters at hand, the judge will need to put in writing that this is clearly understood, fully disclosed, and acknowledged. The presumption of incompetence. This is another one they do. Is the presumption that you are at least ignorant of the law and therefore incompetent to present yourself and argue property. I think it's maybe properly. Therefore, the judge/magistrate as executor has the right to have you arrested, detained, fined, forced into psychiatric evaluation, unless this presumption is openly challenged to the fact that you know your position. It's another one that I have to deal with. And actively rebuke and object to any contrary presumptions, then it stands at the time of pleading that you are incompetent. then the judge or magistrate can do whatever they need to keep you obedient. This is rebutted. The law is under scrutiny for its contribution to the current state of the planet, the distribution of rights and resources, and the destruction of divine law. In discussion regarding such matters, no privilege or deeming us incompetent is permitted. This is all the Pope's Roman law / canon law, and unconstitutional is described herein. The presumption of guilt is the presumption that it is assumed to be a private business meeting in the bar guild. You are guilty whether you plead guilty, do not plead, or plead not guilty. Therefore, unless you either have previously prepared an affidavit of trust and motion to dismiss with extreme prejudice into the public record, or called demur, that the presumption is you are guilty, and the private bar guild can hold you until a bond is prepared and guaranteed the amount the guild wants to profit from you. This is rebutted. Under no circumstances is the presumption of guilt allowed, as I am deemed property of my Creator, forgiven of all sin. And that's the end of it. So I was actually thinking of turning it into an affidavit and recording it as an affidavit in the county is what I was thinking of doing. But I got to deal with this stuff about the executor and
So at first you said it was going to be an exhibit, or?
Well, yes. This is one that somebody else made up, right? And it was going to be an exhibit to something else.
Okay, that's where I got it from.
Yeah.
Oh, got it.
But so what happened is the other person that did this was actually convicted and served some time, and so she also is a lady. She also made up a
jurisprudence. Did I say it right?
No, a notice of resignation and substitution of trustee. And so she basically noticed them that she was, because when you get convicted, then you're convicted as the trustee. You see what I'm saying? And so she resigned as trustee, and she created another trust, and she made the court the trustee, and she said that it's quite interesting. It's really quite interesting. But you know, I don't know if we want to go through that. This is actually a document that someone else created. Anyways, and where she was.
I was gonna, mention that. I think it was on point 2 where you're talking about being captive, and another word for that is ward of the state. I just wanted to add that in there if that was of any interest. Sorry.
Yeah, well, that's again a trust. It's all trust laws. What's going on?
Yeah, we know it.
So
that's how they're getting the payments.
Is it better?
Sorry?
I have a question. Point the clerk or the judge, the trustee, and let them know, what's that magic word? You express the trust and put them on notice that they are in fact the trustee and I am the benefactor, and something else too, real quick.
Well, you can do
which
that.
one should I do?
That can work, but what happens? Like the guy that I know that does that will say that, and the judge will get off, throw off his black robe, and walk out, and then he'll come back in a different jurisdiction. But I'm not exactly sure what that jurisdiction is, or how to deal with it. So that's my problem, is that, you know, I don't know, and so I don't want to tell people to do that, not knowing what's happening exactly and how to deal with it. But
I had a judge on Zoom, and he said, I can't hear her. I can't hear her. This has never happened ever. let me come in and out. And he came back, and I'm sure he did a little happy dance on his side. So, if he does that again, should I, he comes back, maybe he does, turns around and touches his nose or whatever, puts on his favorite socks or something. I don't know. It's something different, though. Should I let that new archetype know that he is, in fact, a trustee as well, and I am a
I don't
benefactor?
know. I don't
Also,
know. I can't tell you. I mean, I don't know. This is kind of new stuff to me, and it's a way of dealing with it. I like these 12 presumptions, but I don't want to. What my attitude is that minor estate's a fraud, it's satanic, it's evil, and I want nothing to do with it, which is what I put in there. But you have to, this the idea of is under equity. You have to have clean hands, and if you participate in a fraud, if I say I'm the executor or the guardian, then I don't have clean hands, and they won't give you a remedy even if they could. And um, I don't know. I wish I could tell you. I don't know.
What about should she make it assumed in her writings that she's a trustee but just not state it?
No, no, no. That's the problem. The trustee pays for everything. So then, if you say I'm a trustee, then you get then you're telling I volunteer to go to jail. Trustee is the one that's got all the liability.
I always remember by my trustee.
So
Remember that? It's always the trustee. He's paying.
what what this friend of mine does is when they call the name, he'll say I'm a beneficiary of a trust with that name, and he'll point at the judge and he'll say, and I hereby appoint you to be trustee, and I demand that you settle this matter immediately. And then he'll say, and now are you going to perform your fiduciary duty, or do I have to sue you for breach of trust? And the judge will get up, throw off his black robe, and walk out. And so I'm telling you, that's powerful. But then what do you do next? I don't know. I wish I could tell you, but I don't know. The real solution is to make it so they don't want to talk to you in the first place, okay? Because anytime they talk to you, that's why I like this. I record this thing, and the affidavit of life is perfect. It's a 2-pager or a 3-pager, and you record that into the public. I've got one that I'm going to record. I'm going to file into a court case, and I've got another one that I'm going to record into the public here in Texas, and one that I'm going to record into the public in Arizona, and that is perfect. That is absolutely perfect. That's a perfect start, at least, because that just shows that you're not dead, and all of a sudden they got a problem. But I don't think that's the only thing to do.
Any yay or naysayers over on YouTube?
I'm looking at the comments on YouTube right now.
Also, I heard this last week. I think I forget. I was told, in fact, the state is the injured party, victim or whatever they put it up, where it's asked for the power of attorney that they have or the affidavit. So, would that be a good avenue to take as far as confronting an assistant state's prosecuting attorney is actually the county?
Well, the best thing to do is claim your constitutional rights. And there was a guy last week that talked about taking witnesses and going to the magistrate and demanding to see your accuser, and they'll never produce a magistrate, And so you do that 3 times, and you take 2 witnesses with you, and you make affidavits and file them into the case. And he said that he made a felony go away by doing that. So again, that's your constitutional rights, and that's the best way to deal with it. That's why I bring up the fact that this thing's a fraud. It's a bill of attainder.
Question that asked the magistrate.
Sorry?
You were buffering at the time when you said that the question that you asked the magistrate. What is it that you asked the magistrates again? Please repeat.
You tell the court that you want them to produce your accuser. You have a right to face accuser under the 6th Amendment, and they'll never produce a magistrate. They'll never come up with one. So all you need to do is tell them that, and they'll never come up with a magistrate because they don't want to answer that question. They can't answer that question. And so then when you do it 3 times and you have 2 witnesses, then they got a problem.
I've heard similar too when they say, who here has a claim against me? And nobody also will never come forward in that scenario also.
Well, if you know how to do that, then that's good. But so the point is that you have to build a case. There are a bunch of thieves and pirates. The Constitution is your most powerful ally, and you got to understand the Constitution, and you got to use it.
About witnesses, my brother was going to be taken away from her, and she went and got 40 people to show up, and they let him go. They dropped the case.
Yeah, no doubt.
Yeah, they got 40 people to show up. She went to church, got 40 people, and they showed up. And
that creates a problem for them for sure.
Yeah.
What state was that?
Texas, Houston. They're corrupt. Me, I'm told I can't bring any witnesses into the courtroom. There's no room for them. They won't let anyone else in with me.
So what you have to do is lay a foundation, go and demand to face your accuser. Go and tell the court you want to see a magistrate because you want to see your accuser, face your accuser. And you bring 2 witnesses, and each time you go, each witness makes a little 1-page affidavit. On this day, I went with you, and you asked to see a magistrate because you wanted to face your accuser, and the clerk said there was none available. And each witness does that, all 3 people, and then all of a sudden they got a problem.
Okay, a lot of stuff has happened to me, but when I get ready this next case is a big case I'm working on. When I get ready, I'm going to list all the cons that I've gone through, and I'll discuss them as what's the best scenario to follow through. And then I'm going to have to find 3 people that will show up at least, or 40 people. I mean,
You just have to remember that it is war. Okay,
it is.
They are the enemy, and you never ever tell the enemy what you're gonna do.
Right.
You set them up and sandbag them.
Okay.
Anyways, so this is the notice of 12 presumptions. It's going to be adjusted and tweaked some more, but this will get you started, maybe I'll just upload it to the group the way it is.
That would be great.
And then I'll upload the let me save this first to make sure it gets saved. Okay, so there's the notice of 12 presumptions. And now let's go through the Amicus curiae.
So do you expect to get that off this week or next week? Maybe?
I'm not sure. I gave it to this friend of mine. He's supposed to. There we go. Just want to make sure it got up to YouTube. He's supposed to do it. So, I gave it to. I wrote it for a friend of mine. He's going to file it into a case. It's going to go to the Court of Appeals. So, actually, the brief, it's over a writ of prohibition, and the petition hasn't been filed yet. So you can't file this until they file a petition, and you get a case number, and then you can file it. So we got to wait. So let's do the Amicus curiae now. Wow, we've almost been an hour on YouTube. So now comes a friend of the court representing an Amicus curiae brief on behalf of Robert Dunlap, providing constitutional challenge of the 1871 corporation at 16 Stat 419, domiciled in the District of Columbia, and its minor estate at 31 CFR 363.6, and the National Bar Foundation are all violations of the organic laws as follows. There are 4 organic laws for the United States of America: the Declaration of Independence, 1776, the Articles of Confederation and Perpetual Union, 1781, the Northwest Ordinance, 1787, and this Constitution for the United States of America, 1787. The District of Columbia 1871 Municipal Corporation at 16 Stat 419 is a violation of the organic laws because it is Roman law from what is now the Vatican. And this is Black's Law Dictionary, revised 4th edition. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiar for itself, more properly called municipal law. Because Rome was the capital of a group of ecclesiastical city-states in the Italian peninsula. Rome, the capital of the Pope's territories and of Italy, anciently the Milrus of the Roman Empire. Rome is still a large and fine city. 1773 Encyclopedia Britannica, Volume 3, page 632. Roman or Papal states stretch across the central part of the Italian peninsula in an oblique direction from the Adriatic to the Mediterranean, and between Tuscany, Medina, and Lombardy in the northwest, and Naples in the southeast area. 17,822 square miles. Population in 1833 was 2.7 million. Capitals: Rome, population 153,000. government and elective monarchy, the Pope for the time being the absolute sovereign, with a consulting assembly of cardinals. And that's Waterston Encyclopedia of Commerce and Mercantile Law, 1863, page 582. Pontificality, the state and government of the Pope of Rome. That's 1830, Johnson's English Dictionary, page 707. And this is stuff that's taken from the modern part of the universal history, from the earliest account of time compiled from the original writers, volume 26. This is about a 40-volume set that I happen to have, digital version of it. Anyways, it's talking about as the ecclesiastical state, okay? And so this Roman or papal states were ecclesiastical states. There's all sorts of references through it. In AD 1198, Cardinal Licarius is chosen pope and takes the name of Innocent III. He receives allegiance from the prefect of Rome and requires homage from all in the ecclesiastical state. And that's the modern part of the universal history. Same thing, volume 25. Civil or municipal law is that which every sovereign kingdom or state has appropriated to itself. The appellation of municipal was originally confined to the laws of the municipia, or dependent states. Actually, that's got to be a T. Right? So municipal is talking about the papal states, the papal city-states, which violates Article 1 of an amendment, which requires Congress shall make no law respecting an establishment of religion. Because Roman law is also ecclesiastical papal law, which is now the Vatican. The ecclesiastical papal states were annexed to the Kingdom of Italy in 1870. This is taken from Wikipedia. During and after the Revolution of 1848, sentiment on the peninsula grew for the establishment of a unified Italian kingdom. Southern Italy had not been united with northern Italy since the early medieval period, being mostly under the rule of the Kingdom of Naples and the Kingdom of the Two Sicilies. Northern Italy in the early 19th century came under the domination of the Kingdom of Sardinia, which, besides its namesake island, also ruled the expansive Piedmont and Savoy regions along the French-Italian borderlands. The formerly Republican leader in southern Italy, Giuseppe Garibaldi, made common cause with the House of Savoy to overthrow the Kingdom of the Two Sicilies, and the people voted in a plebiscite to join Sardinia to form the Kingdom of Italy in 1861. The Papal States and the city of Rome were annexed to the kingdom in 1870, completing the unification of Italy. The kingdom lasted until the aftermath of World War II, when 1946 Italian institutional referendum ended the monarchy, which failed to change the character of the Papal States, being ecclesiastical. And in 1871, so 1870, the Papal States were annexed to the Kingdom of Italy. 1871, a year later, Congress approved an act to provide a government for the District of Columbia at 16 Stat 419, that all that part of the territory of the United States included within the limits of the District of Columbia be, and the same is, hereby created into a government by the name of the District of Columbia, by which name it is hereby constituted a body corporate for municipal purposes, and is bringing the Vatican's Roman law onto the land of America, which uses fraud and deception to supersede and replace common law. There's no common law offenses. Against the United States, only those acts which Congress has forbidden with penalties for disobedience of command or crimes. Under Texas law, no act or omission is a crime unless made so by statute, which is what precipitated the War of Independence, as found in the Cause of Necessities for Taking Up Arms, 1775. Statutes have been passed extending courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, instead thereof to publish and order the use and exercise of the law martial, and for altering fundamentally the form of government established by charter, we saw the misery to which such despotism would reduce us. That's dictatorship, folks. And it's also talked about as some of the reasons for the separation from the tyrant in the organic law of the Declaration of Independence. He has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, which can only be talking about Roman law. Because the Crown of England and the kingdoms of England and Ireland are owned by the Vatican. Not long after that, by general excommunication of the king and people of several years, because they would not suffer an archbishop to be imposed upon them, King John was reduced to such straits that he surrendered his kingdom to Pope Innocent III to receive them again and hold them of him under the rent of 1,000 marks. Because King John gave them to the Pope's ecclesiastical state and agreed to rent them back with the concessions to the Pope in 1213. We will establish a perpetual obligation and concession, which we will establish that from the proper and special revenues of our aforesaid kingdom for all the service and customs which we ought to render for them, saving in all things the penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling. And as thereby became the tool of the Pope, and the Pope's tool passed the Sesquiv Act of 1666, yet still it was found difficult to set bounds to ecclesiastical ingenuity, for when they were driven out of all their former holds, they devised a new method of conveyance by which the lands were granted not to themselves directly, but to nominal fiefs, to the use of the religious houses, thus distinguishing between the possession and the use, and the receiving the actual profit, while the season of the land remained in a nominal fief, who was held by the courts of equity, then under the direction of the clergy. That's the Roman cult, folks, and that ecclesiastical ingenuity is talking about the Roman cult, to be bound in conscience to account to assist use for the rents and emoluments of the estate. That's taxes. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. The use is short for usufruct. And the sestique use is a fiction of law under the Pope's Roman law invented by the praetors of Rome under the pretense of doing equity. Fictions were invented by the Roman praetors under the pretense of doing equity, but are actually fictions of law, owe their origin to the legislative usurpations of the bench, which is also why bills of attainder are prohibited under the Constitution, Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1, as described here when it was brought into America with the Code of Law for the District of Columbia. The legal estate shall be in necessity use at 31 Stat 1432, which is now codified at 31 CFR 363.6, which is also unconstitutional, Article 1 an amendment, because Congress shall make no law respecting an establishment of religion. And a use is short for usufruct under the Vatican's Roman law. Those things which perish by capitis diminutio, which kind are usufruct, an obligation to services on the part of freemen contracted by oath, and matters enforceable by a statutable action, which is a type of trust, which is a dead thing and has no rights, which means most, if not all, court cases are dealing with the Roman law of trusts, which means they're administrative law under the Vatican's Roman law. Courts ecclesiastical, proceedings of the ecclesiastical courts, according to the civil and canon law, by citation, libel, answer upon oath, proof of witness, presumptions, and after sentences for contempt by excommunication and sentences disliked by appeal. An administrator, a person authorized to manage and distribute the estate of an intestate or of a testator who has no executor. In English law, administrators are the officers of the ordinary appointed by him in pursuance of the statute, and their title and authority are derived exclusively from the ecclesiastical judge by grants called letters of administration. At first, the ordinary was appointed administrator under the Statute of Westminster, required the ordinary to appoint the next of kin in the relations by blood of the deceased. Ordinary, a civil law term for any judge who hath ordinary to take cognizance of cases of his own right and not by deputation. by the common laws taken for him to hath ordinary and exempt or immediate jurisdiction in causes ecclesiastical. The same is applied to a bishop who hath original jurisdiction, and an archbishop is the ordinary of the whole province to visit and receive appeals from inferior jurisdictions. The word ordinary is also used for every commissary and official of the bishop under the ecclesiastical judge having judicial power, or an archdeacon is an ordinary. And ordinaries may grant administration of intestates estates. But the bishop of the diocese has is the true and only ordinary to certify excommunications, lawfulness of marriage, and such ecclesiastical and spiritual acts to the judges of the common law. For he's the person to whom the court is to write such things. And that's Tomlin's Law Dictionary. Which is ecclesiastical, comes from now as the Vatican. Roman or papal states stretch across the central part of the Italian peninsula in an oblique direction from the Adriatic to the Mediterranean, between Tuscany, Modena, and Lombardy on the northwest, and Naples in the southeast area.
You say
17,822 square miles. Population in 1833, 2.7 million. Rome, capital Rome. Population 153,000. Government and elective monarchy. The Pope for the time being, the absolute sovereign, with a consulting assembly of cardinals. And that's Waterston Encyclopedia of Commerce and Mercantile Law. Yes, was somebody going to say something?
I thought you paused. Did you say Lombardy?
I can't hear you.
Is in Lombardy Trophy?
Lombardy
I was wondering,
is a city-state
the boundaries.
in Italy.
Did you catch up, Mary?
Okay, so let's keep going. And continues to this day. This is the Lateran Pact, Article 4, 1929. The sovereignty and exclusive jurisdiction over Vatican City, which Italy recognizes as pertaining to the Holy See, forbid any intervention therein on the part of the Italian government, or that any authority other than that of the Holy See shall be there acknowledged. And like the Crown of England and the Kingdoms of England and Ireland, the 1871 corporation is now owned and operated by the Vatican because of the bankruptcy. It's an established fact that the United States federal government's been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent. HJR 192, 73rd Congress in session, June 5, 1933. Joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States and the official capacities of the United States governmental offices, officers, and departments, and as further evidence that the United States federal government exists today in name only. And as evidenced by the Roman Achaea military staff, which is planted on all conquered nations on the right side of the Speaker's podium in the U.S. House of Representatives, and the two Roman fasces, bundle of rods bound into a weapon, symbolizing subservient under the rule of a single man, on the wall on each side of the Speaker's podium in the U.S. House of Representatives. And the Pope even came to address Congress on 24th of September 2015, which is also why Nancy Pelosi, when she was Speaker, would say, we can't read this bill until after we pass it, because she was taking orders from her Vatican handlers. But all of that is unconstitutional and in violation of the organic laws and Article 1 and Amendment, because common law is the law of the land, which has always been here. The individual may stand upon his constitutional rights as a citizen. His rights are such as existed by the law of the land long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are refusal to incriminate himself and the immunity of himself and his property from arrest or seizure, except under the warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights. Every system of law known to civilized society generated from or had as its component one of three well-known systems of ethics: pagan, Stoic, or Christian. The common law draws its subsistence from the latter. Its roots go deep into that system. The Christian concept of right and wrong and justice motivates every rule of equity. It is the guide by which we dissolve domestic frictions and the rule by which all legal controversies are settled. And the Vatican's Roman law is full of fraud and deception, which is satanic, which is the same reason we took up arms against the Vatican's tyrant. For all the grievances listed in the organic law, the Declaration of Independence, and because of it, most, if all not, court cases are administrative inquisitions. An inquisition is one way of proceeding in ecclesiastical court. Courts ecclesiastical, spiritual courts, are those courts which are held by the king's authority as supreme governor of the church for matters which chiefly concern religion, and the laws and constitutions whereby the Church of England is governed. Diverse immemorial customs, our own provincial constitutions, and the canons made in convocations, especially those in the year of 1603. Much oppression having been exercised through the channel of these courts on persons charged with trifling offenses within their spiritual jurisdiction. Gee, that sounds like what's going on today with Trump and a bunch of other people. Comparatorium in the civil law provides a judicial inquest made by delegates or commissioners to find out or relate the truth of a cause. I think all court cases are a comparatorium because they don't have real 12-man juries. It's an inquisition. The Roman or Papal States, the history of Italy, I've already read those, which continues to this day. And this is the Lateran Pact, Article 4. I already read that. And use it as justification to assault people with the Commerce Clause, Article 1, Section 8, Clause 3, in violation of Article 1, Section 8, Clause 17, to deceptively assault people with a quasi-contract, a sumpsit. In its origin, an action of tort, a sumpsit was soon transformed into an action of contract, becoming afterwards a remedy where there was neither tort nor contract, based at first only upon an express promise. It was afterwards supported upon an implied promise and even upon a fictitious promise. Introduced as a special manifestation of the action in the case, it soon acquired the dignity of a distinct form of action, which superseded debt, became concurrent with account. See, these are commercial words. And with case upon a bailment, a warranty, and bills of exchange, and competed with equity in the case of generally equitable quasi-contracts. Going out of the principle of unjust enrichment, surely it'd be hard to find a better way of illustrating the flexibility and power of self-government of the common law. Both in Roman and in English law, there are certain obligations which were not in truth contractual, but which the law treats as if they were. They're contracted in law, but not in fact. They're fictitious, being the subject matter of a fictitious expansion of the sphere of contract to cover obligations which do not in reality fall within it, which requires the Vatican's minor estate, U.S. citizen, or other fiction. Quasi-constructive contracts are based solely upon the legal fiction or fiction of law. And what did I say about fictions? The Roman praetors created fictions, which is why the Vatican's fictitious minor estate under the Vatican's Roman law and fraud and deception at capitis diminutio is the destruction of the caput of legal personality. Capitis diminutio, so to speak, wipes out the former individual and puts a new one in his place. And between the old and the new individuals, there is, legally speaking, nothing in common. A juristic personality may be thus destroyed in one of three ways: by loss of status civitatis, this is the capitis diminutio maxima; by loss of status civitatis, it's the capitis diminutio media; and by severance from the agnatic family, this entails capitis diminutio minima. Textbook in the history of the system of Roman private law. It's all contracts. Private law is contracts. Capitis diminutio maxima, meaning a maximum loss of status through the use of capitalization. The highest and most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage, when he became a slave, swept away all the rights of citizenship and family rights. Black's Law Dictionary, 4th edition, because the Vatican's fraud and deception at Capitis Diminutio Maxima is used when they enslave people, and their Satanists using fraud and deception to sell people into slavery as collateral for their minor estate. He, the prisoner, has as a consequence of his crime not only forfeited his liberty, but all his personal rights except those the law which the law and its humanity affords him. He is for the time being a slave of the state, which are non-judicial proceedings, because whenever a statute's involved, the Vatican's fake judge is actually a bought and paid for clerk masquerading as a judge. When acting to enforce the statute and subsequent amendments to the present day, the judge in municipal court is acting as an administrative officer and not in a judicial capacity. Courts administrating or enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent for the involved agency, but only in a ministerial and not a discretionary capacity. It's the accepted rule, not in the state courts, but in the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes. As a ministerial clerk, judges who become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency, which is why it's a bill of pains and penalties. I think I'm going to modify that. Let me just look here. Well, there's still a bunch of pages. Sorry?
Just scroll up on your page. I can't see.
Well, all you got to do is download the file that I just uploaded to the group.
Oh, thank you.
Let me look. Damn. How did this thing get way up there? Oh, I guess I didn't upload it. I'll upload it right now.
Thank you.
Okay, it's uploaded now. So I think, let me look, this is page 11. There's still another 7 pages, so I'm sure that's in there. Let's do this. So what the heck? Yeah. Yeah. It's down there further, a couple pages. Okay. So, bill of attainder means legislative acts, no matter what their form, that apply either to named individuals or to easily ascertainable members of a group. Bill of pains and penalties is a legislative act, though similar to a bill of attainder, prescribes punishment less severe than capital punishment. So, bill of pains and penalties is anything less than a death sentence. Also means they have no authority to do anything judicial and fraudulently and deceptively presenting themselves as a court of law. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. The legislative inferior court might be a superior court of general jurisdiction under some circumstances. A court of general jurisdiction is presumed to be acting within its jurisdiction till the contrary is shown. But when a superior court of general jurisdiction undertakes anything that's in derogation of common law, it becomes quad hoc, an inferior court of limited jurisdiction. And their maritime civil codes have absolutely nothing to do with common law. When, therefore, a court of general jurisdiction proceeds under a special statute, it becomes a court of limited jurisdiction for the purpose of such proceeding. Accordingly, where a court of general jurisdiction undertakes to carry out a special power, a decision made in the exercise of such power is treated as a ruling of a court of limited jurisdiction, and the presumption applicable to a court of general jurisdiction that it acted within the scope of its jurisdiction does not apply. It is familiar law that when a special statutory authority in derogation of common law is conferred on courts of general jurisdiction, such a court of general jurisdiction becomes quad hoc, a court of inferior or limited jurisdiction. Therefore, it's actually an administrative hearing under Roman law of trusts. A ministerial act is an act that public officers are required to perform in a prescribed manner in obedience to the mandate of legal authority and without regard to his own judgment or opinion concerning such act's propriety or impropriety when a given state of facts exists. When acting to enforce a statute and subsequent amendments to the present date, judge of municipal court is acting as an administrative officer, not in a judicial capacity. Courts administering and enforcing statutes do not act judicially, but merely ministerially. So that's all Roman law. They're using Roman law words here. Accepted rule not in state courts, but of the federal courts as well. When a judge is enforcing administrative law, they're described as mere extensions of the administrative agency, which is fraud and deceptive because it's actually an executive agency working for the legislative branch. The word administrative is synonymous with the word executive. The word administrative connotes of or pertains to administration, especially management, as by managing or conducting or superintending the execution, application, or conduct of persons or things. Black's Law Dictionary. Thus, an administrative act of those acts which are necessary to be done to carry out legislative policies and purposes already declared by the legislative body. When the legislator desires to accomplish his object, he need not feign, he commands. Fictions of law owe their origins to the legislative usurpation of the bench. That's Bouvier's Law Dictionary, 1856 edition, which is full of fraud and deception because there is no judge for that proceeding, is actually a bought and paid for clerk masquerading as a judge that cannot do anything judicial. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. Where there is no jurisdiction, there is no judge. The proceeding is as nothing. Such has been the law from the days of Marshal Saya. To put the petitioner into bondage, selling the petitioner into slavery as collateral for the Vatican's minor estate, because an entity includes the estate of a living person, such as an incompetent or a minor. Entity, this is 31 CFR 363.6, and a minor can be an individual who has attained the age of 18 years but has not yet taken control of the securities in his or her minor account. BAR's acronym for British Accredited Regency, at least since the Bar Treaty of 1947, and the bar is domiciled in the Vatican-owned and operated City of London. Inns of court, certain private unincorporated associations in the nature of collegiate houses located in London, invested with the exclusive privilege of calling men to the bar. And they're claiming immunity under the International Organization Immunity Act of 1945, 59 Stat 669. They're here as regents for the Vatican under the ecclesiastical Roman law. A regency is the office or jurisdiction of a region or body of regents, a government or authority by regents. Because the 1871 corporation went bankrupt in 1933, it's an established fact that the United States federal government's been dissolved by the Emergency Banking Act. Since March 9, 1933, the United States has been declared state in a declared national emergency. Under the powers delegated by these statutes, the president may seize property or organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel in a plethora of particular ways, control the lives of all American citizens. The majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have, in varying degrees, been abridged by laws brought into force by states of national emergency. And it all started on the same day, March 9th, 1933. And it's now owned and operated by the Vatican, as previously described herein, and the Code of Law for the District of Columbia, as known as the United States Code, requires all judges to be members of the bar. And approximately 70 to 90% of all legislators in state and federal legislatures are bar members. They're fraudulently and deceptively used in the Vatican's Roman minor estate to bring the District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17, which is using the Vatican's fraud and deception to unlawfully place Dunlap under the Commerce Clause. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power nationally covers those citizens even in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. Because plenary power is a dictatorship under the Vatican's Roman law. Plenary jurisdiction accords full and absolute power with the subject matter and parties in the case. Plenary, full, complete, entire. Plenary, full, complete in the courts of admiralty and the English ecclesiastical courts. It's going from the Roman law. Plenary is a plenary power, is a plenary authority, is complete and absolute power to take action on a particular issue with no limitations. It's derived from the Latin term plenus. Plenary power, complete hour over a particular area with no limitations. This term is often used to describe the commerce power of Congress under the Commerce Clause, Article 1, Section 8, Clause 3. Congress is granted full power over interstate commerce. The court has found that states are not able to pass laws affecting interstate commerce without the permission of Congress. Most of all, not all court cases are administrative proceedings, which is dealing with the minor estate, fiction of law, presumptions, and the Vatican's Roman law of trusts. The prisons are populated with slaves because a slave is a thing and has no rights. He, the prisoner, has as a consequence of his crime not only forfeited his liberty, but all his personal rights except those which the law and its humanity affords him. He is for the time being a slave of the state. Because of the administrative proceedings under the Vatican's Roman law, there are more people in prison in America as a percentage of the population than there are in communist China, or in the Soviet Union, or the worst dictatorship in history. And if there were Christians here, the bar members would be getting their necks stretched. If a man be found stealing any of his brethren of the children of Israel, maketh merchandise of him, or selleth him, then that thief shall die. Thou shalt put evil away from among you. And the Innocent Project estimates that 60% of prisoners are innocent. But it's such good business for the Vatican and the Roman law so-called courts, which is one of the grievances of the organic law of the Declaration of Independence, 1776. He's plundered our seas, ravaged our coasts, burned our town, and destroyed the lives of our people. This is prohibiting the free exercise of Dunlap's religious beliefs in violation of Article 1, Congress shall make no law respecting an established remnant or prohibiting the free exercise thereof. As a Christian, which means they're satanic, because the Vatican's a necromancer with their minor estate, or is bringing dead things to life, and prohibited under God's laws found in the Holy Bible. This is Deuteronomy 18. There shall not be found among you anyone that maketh a son or daughter to pass through the fire, that useth divination, or the observer of times, or an enchanter, or a witch, or a charmer, or a consulter with familiar spirits, or a wizard, or a necromancer. For all these things are an abomination unto the Lord, and because of these abominations the Lord thy God doth drive them out from before thee. And they're using fraud and deception of the Vatican's minor estate to engage in the theft of Dunlap and populate the prisons by selling people into slavery. And all fraud and deception and lies come from the devil and Satan. You're the father of the devil, and the lusts of your father you will do. He was a murderer from the beginning, and abode not in the truth, because there is no truth in him. When he speaketh a lie, he speaketh of his own, for he is the liar and the father of it. That's John 8:44. I know the blasphemy of them that say they are Jews or Christians and are not, but are the synagogue of Satan. And that's the end of it. So I prepared this for a friend of mine to file it into a petition for writ of prohibition that we're filing into a case. So we'll see. That's all I can say. But these are all similar arguments that I did also in a letter to Trump, because I wanted Trump to be aware of the fact that this stuff is going on. I'm actually thinking of doing a Rule 11 emergency petition to the Supreme Court, but they may or may not accept it, so we'll see.
Can you show us the letter to Trump now?
Sorry?
Would you show us the letter to Trump now, or next week? You gotta
Yeah, why don't we do that one next
spill
week?
that.
We're an hour and a half in, so it's now quarter to 12 on the East Coast. So
Right. Okay, so
we can do that next week.
yeah, I appreciate your time. Okay, I'll hold you to it. You know that.
Okay,
But
yeah, do that. Remind me. Don't let me forget.
you know I won't. If anybody has any more questions, we'll wrap it up and let Glenn close it up for the night.
Damn, I haven't been showing this.
I'll be tuning in next week.
I haven't been showing this. You guys haven't
You're
been seeing
showing it. Why? What were you trying to show?
this Amicus curiae.
Yeah, we're seeing it. You're sharing screen. Yeah.
Exhibit D, mandatory judicial notice of 12 presumptions.
Well, I'm looking in Telegram right now, and that's the mandatory judicial notice of 12 presumptions. I uploaded it, and so you have the Word file. You can get the Word file and read it for yourself. Yeah, somebody should have said something. It's not been on Telegram. That's the mandatory judicial notice. We went through all that already, but that Amicus curiae is a separate document.
That's like a 20.
That's my fault. I guess I should have paid attention to the screen flipping up or flipping over.
There it is, right there. I got it there, but
oh, now I see
it's a
the
little late
difference.
to
Yeah.
go through it. It's like
Well,
18 pages.
And so, how much of that did you take out for the Trump letter?
There's a bunch of it that's in the Trump letter. The Trump letter was there was some other stuff in the Trump letter too. There was the stuff about the fact that the 1871 corporation and the minor estate and the bar are unconstitutional. Actually, when you start looking at that, there's a whole bunch of stuff. The Bank Act, the Securities Act. There's a bunch of stuff that's unconstitutional because it's all Roman law. There's a bunch of stuff that's passed by Congress that's Roman law. But I just want to bring up about the 1871 corporation and the minor estate. That's the stuff that affects me. The rest of that stuff, I can avoid, but they can't. You can't avoid that minor estate. They'll just assault you with it, and they do. I've been assaulted with it, and so 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 that's what this is right here. Yeah, I'm sorry, but at any rate, I uploaded the Word document. The Word file is uploaded to my page on the group, so you can download it. The mandatory judicial notice with the 12 presumptions. It's uploaded to the group, and so is the Amicus curiae. And so you got the Word files.
Okay, so if someone wanted to formulate their cases with the 12 presumptions, would it be good to add it in as an exhibit? And if they were going to do another affidavit for, stipulating their case?
I would make it under penalty of perjury and file it into the case as an affidavit. But there's stuff I already talked to you about changing. It's up to you whether you want to change that stuff or not.
Yeah.
So you might want to. Right now, it's kind of mixing things a little bit. So you gotta, I wouldn't file it the way it is. Let me put it that way.
Yeah, you clarified that for us, which was good.
But it gives you the 12 presumptions or valid presumptions, and in the original document, none of those court citations are in the original document. I added all that stuff in. So I mean, all she did really is just rebut them and say it's rebutted. And
that's what we want to do.
Yeah.
So is just one last thing is, have you heard anything down the pike about the global shield plan between U.S. and Canada?
Well, Alberta sent a delegation to Washington to join the union. I don't know what came out of it, but I know that there was a bunch of lawyers from Alberta that went to Washington and to talk to Trump.
I know.
But I don't know anything about any other provinces.
Well, the Global Shield plan was stated by who, Carnival Man, that it was going to be announced in the next couple of days, this Global Shield plan. And then, do you know that he put $30 billion into green energy? Or he donated $30 billion to green energy on Canada's behalf. Now, isn't that spending our money valuably?
Well, I think that you have a full communist dictatorship in Canada. I'm glad I'm not there. And once this exceedingly starts coming through, you're welcome to come down and hang out in Texas. Get away from that communist country. You could even call yourself a political refugee. I think you could probably do that because it's communist Canada.
I think I could get away with it now more than ever.
Well, I think, quite frankly, there's a lot of Canadians that are already down here. I know lots of people that have been down here without green cards. They buy and sell real estate. They do stuff, and they've never they go back and forth. I don't know how they get across the border all the time. I think they just tell them they're coming to visit. But I know that there's a lot of people, a lot of Canadians that come down here. This is a pretty major Canadian community down here, quite frankly. And I don't think they're particularly concerned about Canadians. It's the other people that come in from the south,
Right, correct. Yeah, there's a few of those around here too.
But if you married an American, then you'd automatically get American nationality too. That's common law.
Yeah, that was an issue since I was 16 years old, or that could have been open to me at 16 years old. So I know I can take that route anytime. But no, I like to walk on my own. I don't know. I like to be my. I don't like to be bought and paid for. If you know what I mean.
You're
Like the.
you like being independent, and I don't blame you.
Mhm.
So not a problem. But
Unlike the
there's lots of ways to
can't.
skin a cat.
Well, I like to say skin a fish because I'm an animal activist. But those crazy Canada Post people are going to go on strike again.
Really?
Yeah, they didn't. Well, they were ordered back to work in December. Late December, right? And so because they were ordered, they gave the government 6 months to give them what they wanted. And of course, the government hasn't come to the table. So, yeah, they're walking out again. And my employment is based through Canada Post. So, another hold up for me, I guess. But
Your
that,
employment?
yeah, I've been doing this letter writing that involves me sending letters through Canada Post. And well, when I first signed up, they were on strike for 2 months, right? And that put me off. And then they wouldn't verify me because I live independently, let's just say. So now I've been verified and I've got the threat of, it's not a threat, they're gonna walk again. They gave 72 hours notice. So by Monday, they'll have the picket signs up again and we won't be able to actively communicate snail mail wise, which isn't a bad thing anymore.
Well, I got to tell you that I just wired my brother, and I was half thinking that they were going to seize it, and they didn't. So, I don't know. I think that they got slapped over the stuff that went down with those truckers and stuff, and I think that they're thinking twice about that stuff. So you just don't know how things are going to change.
No, a lot of court action stuff's been going on about that, Larry. Like
I'll bet.
a lot of banking. I've even got my own bank basically in a default situation, and I've submitted a TILA report against them and what they've tried to pull on me, and I've submitted a W8 Ben, which means they cannot withhold any funds from me because they're a foreign entity. So that's also messed them up a little bit. So, yeah, the banks are bad here. But yeah, they have been slapped, I think. And I'm glad that you were able to send money to Canada. And I want you to check in. I know we talked earlier about the Wise app, and you said that you didn't have success sending funds through to where you were going. But I've just set it up and I want to try it again. We'll just do kind of like a small test thing.
Whatever.
If you're on there, then I can easily, like, so the funds that I sent you at 160, if I would have sent it through that app, I could have got a rate at 170. So that's a pretty big deal, right? I think the banks aren't getting it, but maybe the app is, and they're not being as greedy. So check into that, and it's hooked up to everything. It's hooked up to all your Bitcoin, everything, right? So we got to test the waters on that.
There's well, I do stuff online all the time, and it works great. I mean, I do stuff with Bitcoin. Matter of fact, I just sent myself $2,200 from a Smart Lab, and I expect I'll get that probably Thursday coming. But
That's pretty fast. That's a fast conversion
well,
because usually,
if you do it before Saturday, then it'll happen the following Thursday, and that's Smart Lab. If I do it, um, it exceedingly happens really fast. It'll happen the same day a lot of times, but Smart Lab takes longer, and they charge you a fee. Exceedingly doesn't charge you a fee.
right, they get you on those fees. I know. Yeah. Well, that's good. You're not doing PayPal and all that other crap.
No,
Yeah, they've
no.
got so many 419 India, Africa, I don't know, gigs set up with them that I've been down with PayPal like $2,000 now, so don't deal with those
Yeah, well, they
dorks, you
ripped
know.
me off for about $500.
Everybody's got a PayPal story. Anyway,
Yeah,
so I don't have any bad jokes.
I would have sued them, except that I just it's in my bucket list.
Yeah, I know it's down on mine too. I've got it. I've got that too. Well, have a great weekend and stay put for a while so I know where you're at. Are you?
Yeah, I'm here. Actually, I'm thinking about going back to Arizona next week, though.
Yeah?
There's a deal going on in Springerville that that I was thinking about going to, and then I was probably going to make a quick trip to Phoenix too. But there's so that's next week, and then I'll probably won't do anything until the it's like the first weekend in August. There's a New Mexico event that I'm planning on, Extraordinary Science Conference in New Mexico.
Is that the one that?
Huh?
Is that the one that Daniel is does every year? He has a group on here, Galaxy. He does a Galaxy group on here.
Yeah, I don't know about Galaxy. This is Extraordinary Science Conference in Albuquerque, and
you went to it last year. All the inventors.
I've been doing it every year, yeah, for quite a while. I helped him set up his YouTube channel, and he's making money off of that. And so he gives me free admission. So they have scientists and stuff there, and they talk about free energy and alternative healing and all sorts of stuff.
Hey, has Richard Gere ever been there? Dr. Richard Greer, Greer.
Might have been. I'll be back in a second.
That Stephen Greer or Richard?
You could be right, Miriam. Yes, he could be Stephen. I'm not. I just know Greer, Dr. Greer. But we should let Glenn wrap it up. Yeah, we should let Glenn wrap it up here. I don't even have any bad jokes for him or anything. So I gotta come around and lighten up a little bit. I know you guys want to hear bad jokes.
Yeah, is that the UFO guy? Stephen Greer.
Stephen Greer, there you go. Yeah.
Yeah,
he taps into this.
He's a UFO guy, and they do have some UFO people that come there. But it's mostly free energy, anti-gravity, cold fusion, alternative healing, all sorts of alternative healing stuff. And
med beds. They have med beds over there.
They have people that talk about them. I didn't see any med beds there. They have, everything like that is kind of primitive right now. It's in early technology.
Right.
It'll be coming out more with more advanced stuff as people develop that stuff.
As it comes to light. Yes.
That's right.
As it comes to light. Well, we won't keep you anymore, Glenn. Thank you for your time tonight, and I hope to hear from you next week. Same time, same place, same, but new info. New
Yep,
info
well,
and
next
new
week we'll-
insight.
Next week we'll talk about Donald Trump's letter that I sent Trump.
Promise? I won't forget. It's on
Don't
my
let me
list.
forget. Don't let me forget.
Okay, well, thank you so much, and ciao for now.
All right, take care. See ya.
You too. Bye.
Bye.